Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our content, please remember to subscribe and hit that notification bell so that you can get alerts of all of our streams. For today's live stream, we are doing a case that just dropped from the United States Supreme Court in free speech as it relates to school campuses. This is one that I've been waiting for with some desire, especially since we listened to the oral argument. And we enjoyed that to varying degrees of enjoyment, particularly the rebuttal portion. Particularly enjoyable. Yeah. Anyways, we have a decision from the U.S. Supreme Court today. Free speech is good. So we're going to read a little bit about free speech is good. And we'll also read some of the dissent and maybe the concurrence depending on time. So Justice Breyer wrote this decision. So we'll see how that works out. And then we'll read, I suppose, some of the dissent, at least, from Justice Thomas and see how his theories work. So, yeah, we'll read all about this and try to figure out what's going on when it comes to free speech on secondary or primary and secondary schools, which is K through 12, which for those of you overseas is from ages about 6 to 18, give or take. So that's what we're looking at, not necessarily college campuses, which have more free speech than K through 12. So whatever the rule is here, it would apply at least as much to college, but maybe more. So we'll talk about the non-college campuses, the under 18 crowd today. Let's get started with this. So we have a decision from Justice Breyer. Okay. A public high school student used and transmitted to her Snapchat friends vulgar languages and gestures criticizing both the school and the school's cheerleading team. The student speech took place outside of school hours and away from the school campus. Important details. This would change if it was on the campus or during school hours or during a school activity, right? So the fact that this is away from school hours and away from the campus and away from a student activity sponsored by the school is going to be significant to the analysis. In response, the school suspended the student for a year from the cheerleading team. We must decide whether the Court of Appeals for the Third Circuit correctly held the decision violated the First Amendment. I thought so. It sounded pretty persuasive to me. Although we do not agree with the reasoning of the Third Circuit, we do agree with its conclusion. Okay, so we'll see what the Supreme Court has to say as to its reasoning and its disagreements with the Third Circuit's reasoning, which I thought was pretty good. So I guess we'll see which one I think is better by the time we're done. BL, who together with her parents was a student at the Mahanoy area school district, a public school. She has since graduated. At the end of her freshman year, BL tried out for a position on the school's varsity squad and for right fielder on a private softball team. She did not make the varsity cheerleading team or get her preferred school softball position, but she was offered a position on the junior varsity team. BL did not accept the coach's decision with good grace, particularly because the squad coaches had placed an entering freshman on the team. So she tried out for a team. She tried out for the varsity team. She was not accepted. Another freshman was accepted. She felt slighted. That weekend, BL and a friend visited the Cocoa Hut, a local convenience store. There, BL used her smartphone to post 2 photos on Snapchat, a social media application that allows users to post photos that disappear after a set period of time. BL posted the images to her story. A feature of the application allows any person in a friends group, BL had about 250 friends, to view the images for a 24-hour period. The first image BL posted showed BL and a friend with middle fingers raised. It bore the caption, F school, F softball, F cheer, F everything. The second image was blank, but for a caption which read, love how me and another student get told we need a year of JV before we make varsity, but that doesn't matter to anyone else. The caption also contained an upside down smiley face emoji. So these are the great sins of BL. Off-campus time, off-campus hours, unrelated to any kind of campus or school-sponsored event, she visited a convenience store, and she posted something to her Snapchat, expressing displeasure at the school's decision, which, may or may not have been justified on its own terms, and she would like to express her thoughts on the matter. All right? So the school has their thoughts on the matter, She'd like to express her thoughts on the matter, but of course, this is a problem. We will see. BL's Snapchat friends included other Mahanoy area high school students, some of whom also belonged to the cheerleading squad. At least one of them, using a separate cell phone, took pictures of the post and shared them with other members of the squad. One of the students who received these photos showed them to her mother, who is a cheerleading squad coach, and the images spread. So we got a little narc here on the cheerleading team. One of the cheerleading students decided to take a picture of this offensive post and share it with her mother/coach, right, of the school. So we got a little cheerleader narc here. The things they said about cheerleader viciousness were real. That week, several cheerleaders and other students approached the coaches, visibly upset about the post. These fainting couch cheerleaders need a little bit of toughening. They didn't even say anything about them or the team. They just said, F cheerleader. I'm so offended. I need to go complain to the coach. How about get a little bit of tougher skin on that one, you know? Not everyone likes cheerleading. Not everyone likes cheerleaders. Not everyone likes this cheerleading team. Get over it, you know? After discussing, I guess we're taking cheer very, very seriously on one front. We're taking cheer very seriously. We want to cheer for the school, and we want to compel everyone else to cheer for the school and the cheer team. That's how serious we are about cheer. Everyone will cheer. It's mandatory. Cheer. After discussing the matter with the school principal, the coaches decide that because the post used profanity in connection with this school's activity, in connection with, not during, mind you, they violated team and school rules. As a result, the coaches suspended BL from the cheerleading squad for the upcoming year. BL's subsequent apologies did not move the school officials. The school's athletic director, principal, the superintendent, and the school board all get involved. All affirm the suspension from the team. You gotta love how this it's just one of those funny things, and you never know when it's gonna happen, right? You never know when it's gonna happen, but it's just every once in a while, a case just pops. For whatever reason, it pops, right? So you just gotta love how this case just continues to pop and pop and pop and pop, right? This thing just starts with one student taking a photograph, and then one student sharing it with a coach, who shares it with the principal, who shares it with the superintendent, who shares it with the school board. And now we're going to share it with the federal court system. And ultimately, we're going to share it with the U.S. Supreme Court. This photo has made its rounds. Can we declare this the most successful Snapchat photo of all time? Because it has escalated all the way to the very top. I'm going to take this to the U.S. Supreme Court. As it turns out, yes, you are going to take it to the U.S. Supreme Court. How exciting. Most successful Snapchat ever. I wonder if we can add the Supreme Court justices as Snapchat friends for the future. Is that okay or not? I don't know. The district court found in BL's favor. The district court said students have speech. It first granted a temporary restraining order and injunction ordering the school to reinstate, and granting the subsequent motion for summary judgment because, there are no facts in dispute, right? So we don't need a trial because there's no facts in dispute, so it's just a question of law. So summary judgment would be appropriate. The district court found that BL Snapchats had not caused a substantial disruption at the school, citing Tinker, which is the go-to case on this issue, dealing with armbands to protest the Vietnam War. Consequently, the district court declared that BL's punishment violated the First Amendment and awarded nominal damages, in other words, $1, and attorney's fees, and ordered the school to expunge the record. So BL wins. Because she wins, there is a fee-shifting statute in play, right? So she wins the $1, her attorneys get paid, and we order the expungement of the discipline. This is going on your permanent record. The district court says, how about no? Again, you got to love that, right? The coach says, this is going on your permanent record. The principal says it's going on your permanent record. The superintendent says it's going on your permanent record. The school board says it's going on your permanent record. The federal district court says, how about no? How about no? How about it doesn't go on your permit record? How about you have to strike that out? This amuses me highly. On appeal, a panel of the Third Circuit also affirmed the conclusion. In doing so, the majority noted the court had previously held the tinker, that a public high school could not constitutionally prohibit a peaceful student public demonstration consisting of pure speech on school property during the school day. All right, so please take note what this does and does not stand for, right? It doesn't relate to activity. It relates to speech. And the Supreme Court in Tinker, which again dealt with students who wanted to wear a black armband in order to protest the Vietnam War. That's what they wanted to do. They wanted to wear a black armband to protest the Vietnam War. It was a black armband. It had no words or anything else on it, right? So it's just symbolic speech. And the Supreme Court in Tinker says, well, that's about as pure First Amendment as it gets, right? Symbolic speech. Like it's a black armband. There's nothing disruptive about it. In fact, if you didn't know what the black armband meant, it doesn't communicate any message to you at all. It's a black armband. It doesn't contain words or any message unto itself. So if you didn't know and you just looked at it, you might be, okay, that's a little weird. They're wearing a black armband. I wonder what it means. It could mean a lot of things, potentially, or maybe nothing at all. Maybe that's just the fashion trend of the time. Who knows? So the Supreme Court says, yeah, that's just about as pure speech as it gets. You're upset because you understand the message. There's nothing inherently disruptive about it. It's not taking away from the school time. It's just a black armband. So this doesn't necessarily extend to anything beyond pure symbolic speech, right? So if it were a shirt with words, or if the students had gotten up and disrupted class, or had walked out in protest, right? Different analysis. But that's not what they did. They wore a black armband. They went to class. They didn't disrupt the class. They just wore a black armband. Supreme Court says, okay, that's fine. You can do that. In reaching the conclusion in Tinker, this court, the Supreme Court, emphasized there's no evidence that the student protest would substantially interfere with the work of the school or impinge on the rights of other students, right? So this protest will not disrupt the school. You're the ones making it disruptive, school, not the students. There is a difference. But the court also said that conduct by a student, in class or out, for which any reason which stems from the time, place, or type of behavior that materially disrupts classwork or involves substantial disorder or invasion of the rights of others is not immunized from the guarantee of freedom of speech. So kind of like so this sort of applies outside the school too, right? So in some ways, this is not really fundamentally different than the rules that apply outside the school. The only way in which it's different is that it changes the nature of the authority that can act. So in some ways, and also maybe is a little bit more cautious than the normal rule that applies. But other than that, it's kind of the same. Maybe it's a little bit more cautious towards preventing disruption than what we'd have otherwise. But, as a general proposition, if you are invading the rights of others, not so much with your freedom. Your freedom stops, your freedom to swing your fist stops at my nose. Your freedom of speech, whatever it is, stops at my freedom, right? And we can imagine all kinds of ways that can manifest. For example, a heckler's veto is a classic example. So can the government prevent you from getting up and heckling another person's speech? Yes. Particularly especially if that person has some sort of permitting, right? They have that time, they have that place, they have it reserved, and you want to get up and be disruptive. No. If you want to have your speech, that's fine. You just can't do it right now and you can't do it right now, and you can't do it right here, right? You can do it somewhere else now, and you can do it here another time, but not both, right? They've got priority because they asked nicely and they got a permit and stuff, right? So your rights stop where somewhere else's rights begin. You cannot disrupt someone else's peace. Fair enough. Many courts have taken this statement as setting a standard that allows schools considerable freedom on campus to discipline students for conduct the First Amendment might otherwise protect. But here, the panel's majority, again going to the Court of Appeals, held that this additional freedom does not apply to off-campus speech. So whatever the freedom might be, a little bit of extra latitude maybe, right? The Court of Appeals said, okay, not so much with the off-campus. It defined as speech that's outside school-owned, operated, or supervised channel that's not reasonably interpreted as bearing the school's imprimatur. So it is not a function of the school. It is not a school activity. It is not a school club. It is not a school event. It is not school-sponsored. It's a person taking a picture of themselves at the Cocoa Hut with Snapchat. You know? Because BL speech took place off campus, the panel concluded Tinker does not apply, which sounded reasonable to me. A concurring member of the panel agreed with the majority, but wrote that the school had not sufficiently justified BL because whether Tinker's standard did or did not apply, it was not substantially disruptive. So the panel went maybe further than is required, which, you know, fair enough, especially in First Amendment domain, because First Amendment maybe is first among equals, which I'm totally comfortable with. You know, the First Amendment is the right that's first among equals. I'm comfortable with this. So we will go further in defending First Amendment rights than we will in any other context, because First Amendment rights are the most important. Because if you disagree with all that, First Amendment is what gives you the right to disagree. So as a practical matter, the one person simply said, okay, I'm not going to decide whether Tinker does or does not apply. I don't have to, because the school didn't do enough to show that if Tinker applied, they could disrupt. And two people said, yeah, we could do that, but we're not going to. We're going to say Tinker does not apply. So we're going to decide perhaps more than we have to, which in the First Amendment domain is not unusual for the courts to go more than they have to. The court could have simply said, okay, the school didn't prove enough and been done. But two people of the majority said, even if they had, it wouldn't have mattered. So they were willing to resolve that question. The school district files a petition for a writ of certiorari in this court, asking us to decide whether Tinker, which holds that public officials may regulate speech that would materially and substantially disrupt the work and discipline of the school, applies to student speech that occurs off campus. We agree with the petition. Again, in some ways, this is not fundamentally different than the rule that would apply off campus to the government at large. There is a general proposition, right, that the government can regulate speech in such a way to preserve the fundamental purpose for which a state-created apparatus exists. Because to hold otherwise would undermine the apparatus, which undermines the fundamental purpose for which the apparatus was created. So the government can regulate speech in such a way, this is a time, place, manner restriction, incidentally, is where this is all flowing from, right? So if you are doing speech in such a way that disrupts the fundamental purpose for which the institution was created, that would be a little bit dumb, because you're undermining the thing. So whatever freedom of speech might mean, it is argued, right? It can't be so far as would disrupt the pedagogical purpose of the school, for example. The school's got a school. If the school can't school, the fundamental purpose of school has failed. So, you know, your First Amendment interests cannot undermine the fundamental purpose of school, during school, that kind of thing, right? So in some ways, that's not really much different than it would apply in other examples for adults in the real world. You know, whatever your freedoms are, again, it can't go so far as to be fundamentally disruptive to the reason that the thing exists in the first place. So yeah, that kind of makes sense in a lot of ways. We have made clear that students do not shed their constitutional rights of freedom of expression, even at the schoolhouse gate. That is the very famous takeaway, right? Freedom of speech does not extinguish at the schoolhouse gate. The most famous line from Tinker. Minors are entitled to significant measure of First Amendment protection. We've also made it clear that courts must apply the First Amendment in light of the special characteristic of the school environment, which is totally fair and probably is true of other environments in general. One such characteristic we have stressed is the fact that schools at times stand in loco parentis, that is, in the place of parents. So that is another way of going about this thing, right? We could go that road, which the Supreme Court didn't really go down that road, But they could say, well, actually, this would be another way to go and tinker. So you could disagree with tinker on its own terms, right? You could disagree with the concept that the First Amendment isn't extinguished at the schoolhouse gate. You could go the other way. And the logic would be, okay, the school is acting in loco parentis, which means they're acting in the stead of the parents, and they take on the position of the parents. Does the First Amendment imply inside the home? No, of course not, because it's not governmental speech, right? So, yeah, so parents have a general, although not absolute, but they have a general ability to rear their children. And that includes the ability to suppress speech and punish for speech, like by grounding, for example. There are limits, of course, to this, right? Like, you can't, there are limits, but as a general proposition, yeah. So you could go the other way and tinker. You could say, okay, well, when the school is acting, although they're the government, they're not really, they're the parent. And parents can do this. So therefore, even though they're the government, they're not really, and therefore the First Amendment doesn't really apply, even though it's a governmental institution, right? You could go that way. The Supreme Court didn't go that way. So much the better, but that would be logical. But even still, there is an idea that the schools at times are acting in loco parentis. So even if you don't take that to its extreme position, there might be a hybrid position in there somewhere, right? All right. The school has previously outlined 3 specific categories of student speech that may be regulated in certain circumstances. Indecent, lewd, or vulgar speech uttered during a school assembly on school grounds, because it's going to disrupt the assembly. Speech uttered during a class trip that promotes illegal drug use. See example, Morse v. Frederick, which to me at least is much better known as the Bong Hits for Jesus case. I love the Bong Hits for Jesus case very much. Yeah, so we can regulate speech uttered during a class trip that promotes illegal drug use. See Morse versus Frederick, otherwise known as the Bong Hits for Jesus case. All right, let me tell you a little bit about the Bong Hits for Jesus case because it's hilarious. There was a school event. I don't remember exactly what was happening, but I think it involved watching running. I don't remember if it was a track meet or if it was a marathon. I don't exactly remember the exact details. Doesn't really matter. There was a school-sponsored event. It might have been a field trip to watch a marathon or whatever. And one of the students, in their infinite wisdom, decides to unfurl a banner. And the banner says, Bong Hits for Jesus. Now, that's a thing that happened. And the Supreme Court said, yeah, you can punish that. Perhaps a controversial decision, one I didn't necessarily agree with at the time. But then again, it did happen during a school-sponsored activity, kind of, sort of. Although the student, I think, I'm trying to remember the details. It's been a while. I think the student might have skipped school that day and gone separately or something, but close enough. The Supreme Court held whatever the details were. So you cannot unfurl your Bong Hits for Jesus banner at a school-sponsored track meet / event to watch a marathon / whatever. Yeah. Speech that others may reasonably perceive as bearing the imprimatur of the school, such as a school-sponsored newspaper. So if it is a school newspaper, then the school can regulate it because it's a school newspaper. So maybe it's the government speech instead of the student speech. Fair enough, right? Good times. Finally, in Tinker, we said that schools have a special interest in regulating speech that materially disrupts schoolwork or involves other substantial disorder or invasion of rights of other. These special characteristics call for special leeway when schools regulate speech that occurs under its own supervision. Again, this logic does apply to adults, maybe just less so. So maybe it applies a little bit more at schools. And the logic of why it would apply a little bit more at schools than, say, for example, and again, when I say schools, let me clarify even further. K through 12 schools. Because the logic does apply less at universities. I know that for a fact. There are cases that definitely establish that as a proposition. Right? So K through 12 schools are treated differently than other government institutions, including other government institutions of learning, such, for example, as public colleges. Right? So this rule probably applies in other instances. It just applies more at K through 12 schools. What would be the reason? Well, the easiest reason would be because they're minors, right? And the pedagogical purpose and the nature of it is a little bit more confined, and so forth and so on. So, yeah. But this reasoning does apply to some degree outside of schools and does apply to some degree to adults for the reasons I said, right? We can't undermine the fundamental purpose for which the governmental thing is being created, right? That wouldn't be fair to everyone else in some ways. Unlike the Third Circuit, we do not believe that special characteristics that give schools additional license to regulate speech always disappear when it occurs off campus. So the Third Circuit took this as a bright line rule. Okay. All right. I'm not sure that's exactly what the Third Circuit said, to be quite honest. The Third Circuit just simply said, tinker doesn't apply off school. I'm not quite sure that they said the additional license doesn't apply, which isn't quite the same thing, but okay. The school's regulatory interest remains significant in some off-campus circumstance. The parties' brief and those of amici list several types of off-campus behavior that may call for school regulation. This includes serious or severe bullying or harassment that targets particular individuals, threats aimed at teachers or students, the failure to follow rules concerning lessons, the writing of papers, the use of computers, or participation in other online school activities, and breaches of school security devices, including material contained with computers. So I'm not necessarily sure that the Third Circuit really disagrees with any of this, but the Supreme Court, I guess, thinks it's important to distinguish anyway, which, is the U.S. Supreme Court, so what the hell? So the U.S. Supreme Court says, okay, the interests of the school to regulate don't disappear at the boundaries of the school. They also go to other things. Those other things have to be more specifically defined, though, than tinker. Tinker, by its own terms, just applies to disruption, which is pretty broad. So if it's off campus, off school hours, off the rest, then yeah, but they have to be more narrowly, specifically defined. Bullying, yes. Harassment, yes. Threats, yes. The failure to follow rules relating to lessons, sure, because that goes to the core academic mission, right? So if, for example, it's like no cheating, or let's make it even a little bit more broader. For the purposes of this exercise, you cannot coordinate or talk to others. You must work completely alone. Right? And students are talking with each other. Can the school regulate that? Yes, because it goes to the school activity, right? Breaches of security devices, because it goes to the core interest. Now, I know and you know that the schools are going to look at every word of that and take it to the absolute limit, and we will have cases trying to figure out exactly what that means. This paragraph just begs for future Supreme Court decisions, right? Here's some examples. Well, what exactly are the bounds of those examples? I see in the future court cases that are going to be arguing over this paragraph for some time. Even BL herself and the amici supporting her would redefine the Third Circuit's off-campus, on-campus distinction, treating it as on-campus all times when the school is responsible. Fair, right? So it's not on campus, which was tinker. It's in the school's domain. Something. The school's immediate surroundings, travel to and from the school, all speech taking place over school laptops, on a school website, speech taking place during remote learning, activities taken for school credit, and communications to the school's email accounts or phones. So if it is within the school's zone, then yeah. But whatever that is, it does not include Snapchat, right? It may be that speech related to extracurricular activities, such as team sports, would also receive special treatment under this proposed rule. Possible. We are uncertain as to the length or content of any such list of appropriate exceptions or carve-out to the Third Circuit's majority rule. Yeah. The rule basically, if not entirely, would deny off-campus applicability of tinker, highly general statements about the nature of schools' special interests. It could be read that way. Particularly given the advent of computer-based learning, we hesitate to determine precisely Which of many school-related off-campus activities belong on such a list? I see litigation in our future. I see many cases trying to figure out what belongs on this list. It's nice when you're able to predict the future. It's like, I see the future coming. Here's what it's going to look like. Yeah. Neither do we know how such a list might vary depending on age, the nature of the off-campus activity, or impact upon the school. I'm just pulling a Nostradamus over here. Can you see into the future on civil law? Yes. Yes, I can. What does the future behold us? Well, I see a lot of cases in our future where various school districts and schools and principals and school boards are doing a lot of stuff and arguing over these paragraphs and words. I can see the future. It's glorious. Involving these words. I can see it. Thus, we do not now set forth a broad, highly general First Amendment rule, stating just what counts as off-campus, and whether or how ordinary First Amendment standards must give way to off-campus to school special need to prevent. For example, substantial disruption of learning-related activities or protection of those who make up a school community. Well, for those of you who are looking for a new legal career, there are a lot of school districts in the United States. There are a lot of schools in the United States. So, yeah, this is an avenue that's available. M. Gabriel says, why is this like listening to stand-up? I feel complimented. Thank you, Gabriel. That's nice. We can, however, mention 3 features of off-campus speech that often, even if not always, litigation, distinguish schools' effort to regulate that speech from their effort to regulate on-campus speech. We've got a 3-feature test. How fun. Those features diminish the strength of the unique educational characteristics that might call for First Amendment leeway. Okay. First, a school in relation to off-campus will rarely stand in loco parentis. Rarely is not the same thing as always. The doctrine of in loco parentis treats school administrators as standing in the place of parents under circumstances where children's actual parents cannot protect, guide, and discipline. Geographically speaking, off-campus speech will normally fall within the zone of parental rather than school-related responsibility. Rarely. Normally. Second, from a speaker's perspective, regulation of off-campus speech when coupled with regulations of on-campus speech include all the speech a student utters during a full 24-hour day. That means court must be more skeptical of a school's effort to regulate off-campus speech. For doing so may mean the school student cannot engage in that type of speech at all. When it comes to political or religious speech that occurs outside school or a school's program activity, the school will have a heavy burden to justify intervention. It's just very sad when you feel like you can it feels very sad when suddenly in your head, you're like, I can predict the next 30 lawsuits that are going to be filed. It's a little bit unsettling when you're like, I can write already in my head 30 lawsuits and their responses and the court's decisions. It's like you can just see the entire future unfolding before your eyes with a little bit of imagination, peering into the veil. It's like, can you in your own mind anticipate the many contexts that this is going to come up? Can you anticipate the next 30 or the next 50 lawsuits over these words and some of the things the schools will do? And can you imagine the lawsuits? And can you imagine the school's responses? And can you imagine the future court's decisions? And it's like in my head, I'm already having this whole panoply of court decisions unfolding inside of my mind. And you could just see the tentacles, and you just see the paths and how they're going to unfold in the future. And you're like, I'm already writing courts of appeal decisions inside my head for lawsuits that haven't happened, for violations that don't exist yet. But, it doesn't take a lot of imagination to see where this is going. So it's like, yeah, I'm writing courts of appeals decisions for things that haven't even happened yet. And I'm writing dissents in my head. Because if you can't see it from this language, I don't know what to tell you. There's a lot of open ground here. Can you write the majority decision and a dissent in a court of appeals case for a violation that hasn't even occurred yet? Yes, I can. With a little bit of imagination, Yes, I can. Third, the school itself has an interest in protecting a student's unpopular expression, especially when expression takes place off campus. America's public schools are nurseries of democracy. Our representative democracy only works if we protect the marketplace of ideas. So this is language trying to pull it back a little bit. All right? Pull it back. This free exchange facilitates an informed public opinion, which transmitted to lawmakers helps produce laws that reflect the people's will. That protection must include the protection of unpopular ideas. For popular ideas have less needed protection, or strictly speaking, no needed protection at all. We don't need the First Amendment for popular ideas. They're popular. Thus, schools have a strong interest in ensuring that future generations understand the workings of practice of the well-known aphorism, I disapprove of what you say, but I'll defend your death the right to say it. And then the court notes, although this is often attributed to Voltaire, it was likely coined by an English writer, Evelyn Beatrice Hall. So the Supreme Court is trying to take away a little bit, right? They're trying to take away. And they're also signposting for the Court of Appeals, right? They are signposting for the Court of Appeals how to decide these cases. Now, I know, and you should be able to figure out what the complaints are going to look like from the school. Apologize, what the responses are going to look like, because this will never come up in terms of the school filing the complaint. That would never happen. Why would it? So you should be able to anticipate in your mind what the response from the school is going to look like in response to the student's lawsuit complaining about the school's discipline. That hasn't even happened yet. Right? Because the school, you can just write it in your head. You're the school's attorney, right? You're the school's attorney, and you want to justify what the school did because they're your client. Right? So the school has done a thing. Does it matter what it does? That it did? Not really. Because you're the school's attorney, and your job is to represent your client. Right? So the school has done a thing and disciplined this person, and a person has now sued, and you're the school's attorney. What is your response going to look like to this lawsuit? And your answer is, oh, okay, well, I have whole bunches of language in here that is giving me an edge. Also, because I'm a governmental institution, you better believe the words qualified immunity are showing up at some point. There's that too. Right? And then you're anticipating in your head, okay, well, what's the counter to all that? What's the attorney for the school student going to do? Oh, they're going to rely on this other language, right? That's trying to pull it back. And what's the Court of Appeals going to do? Or what should the Court of Appeals do with this language? It depends who's writing it, I guess. Because there's language for the Court of Appeals to go either way, but the Supreme Court is suggesting, hinting, signposting that the Court of Appeals probably should go out of its way to defer to the freedom of speech and against the schools. Will that be what happens? Will the Courts of Appeals do that? I don't know. Who's sitting on the panel? So I can't tell you what the decision will be, but I can write well, let me put it this way. I can write the majority and the minority decision. I just can't tell you which is which. I can write the majority and the minority decision. I just can't tell you which is which. Because he's like, you can see it all coming in the future. You just can see it all happening, unfolding. It's the signposting is very, very thick here. Given many kinds of off-campus speech, the different political potential schools related and circumstance-specific considerations, and differing extent to which the justifications may call for First Amendment leeway, we can, as a general matter, say little more than this. Taken together, these three features of much off-campus speech mean the leeway the First Amendment grants to schools in light of their special characteristics is diminished, not extinguished, diminished. We leave for future cases to decide where, when, and how these features mean off-campus speech will make the critical difference. This case, however, can provide one example. Everyone knows what's happening, right? Everyone sees the future, right? Yeah, we all see the future on this one, right? Okay, great. Consider BL speech. Putting aside the vulgar language, the listener would hear criticism of the team's coaches, and the school, in a word or two. Criticism of the rules of a community in which BL forms a part. This criticism did not involve features that would place it outside the First Amendment's ordinary protection. BL's post, while crude, did not amount to fighting words. Fighting words is a hard trigger to pull, man. Fighting words still technically, I mean, I guess it is still a thing because the Supreme Court's never overruled it, but you would not be faulted. The Supreme Court's never said that fighting words isn't a thing anymore, but you wouldn't be faulted for saying that it's not a thing because it's thin. So, yeah, fighting words is probably not, what you want to, And while BL used vulgarity, her speech was not obscene. See Cohen versus California. Nice citation. Cohen versus California. Cohen versus California is such a great case. Because of what happened. Cohen, for reasons I forget, it's 1971, so I'm going to go with Vietnam or race riots or whatever. It's 1971, so you can probably figure out why Cohen does this. Cohen walks into a courthouse with a leather jacket, and the leather jacket is emblazoned with the words, "Fuck the police." That's Cohen versus California. You gotta love this guy a little bit, right? His opinion is embroidered on his leather jacket, which he's kind of ruined, but that's neither here nor there. And yeah, that's vulgar, but it's definitely not legally obscene. I'm not 100% sure it's possible to be legally obscene with pure words, but I'm sure someone could try. To the contrary, BL uttered the kind of pure speech to which, were she adult, the First Amendment would provide a strong protection. Consider, too, when, where, and how BL spoke. Her post appeared outside of school hours from a location outside the school. She did not identify the school in her post or target any member of the school community with vulgar or abusive language. This is an important detail. This is also going back to the earlier idea of bullying, which the Supreme Court also noted as a potential instance for the Court of Appeals to potentially act, right? So the fact that she's not targeting any member of the school community in particular, either explicitly by name or implicitly, so you can see that as a lawsuit coming up in the future, right? Because they didn't mention the person by name, but somehow everyone knows who they're talking about, right? So does that count or not? Because it's implicit. Future lawsuit, future Court of Appeals decision, it writes itself, you know? BL also transmitted her speech through her personal cell phone to an audience consisting of her private circle of Snapchat friends. No. I just got a very weird Discord message. Someone said, "Are you Nate?" No, I am not Nate. I'm pretty sure. was I? BL also transmitted her speech through her personal cell phone to an audience consisting of her private circle of Snapchat friends. These features of her speech, while risking transmission to the school itself, nonetheless diminished the school's interest in punishing BL's utterance. This is interesting too. I don't know whether or not this will inform at all, and it's a little bit late in sort of time. But there's that case right now with the student who posted a picture of their AR in Michigan, right? But didn't send it to certain people. So this language could influence that analysis if the Court of Appeals of the state is so inclined. They already had oral argument though. If that attorney representing that kid is not filing a supplemental brief right about now, because there's language here. It's like, I should bring this to your attention as you're trying to decide this, right? But what about the school's But what about the school's interest here? Primarily an interest in prohibiting schools from using vulgar language to criticize a school team or coaches, at least that criticism that might be transmitted. We can break that general interest into 3 parts. Before we do that, let me just answer a few questions that came up on Discord. If you want to ask me a question, just remember to start your post with either @uncivil or the word question. Either one will be fine, and then it pops up in Discord and I can remember to answer them. Ewan Marshall asks, can we have the team cheer the Snapchat text? That'd be cute. Matthew says, does going into a Scott's case count as a permanent record? Cute. Washington Daily says, I'm surprised they did not bring up the issue of the cheerleaders' communication unlawfully intercepted. Unlawfully intercepted? Probably not. I don't know if it's unlawfully intercepted. Especially given the recent decision on the Computer Fraud and Abuse Act dealing with the thing. So I don't think the CFAA applies. So it's not unlawful, even if it's in violation of terms of service. And Steven said, thank you for breaking this down. You're very informative and not boring. Excellent. I aim to be informative and not boring. Right? I aim to make this enjoyable because I think it's enjoyable. I like this stuff. I think it's great. So I'm going to show you how I like it, and you will like it too, hopefully. It's great. Where's my... Okay. Where was I? First, we consider the school's interest in teaching good manners and consequently in punishing the use of vulgar language aimed at the part of the school community. The strength of this anti-vulgarity interest is weakened considerably by the fact that BL spoke outside the school on her own time. See, for example, Morse, which is the bong hits for cheeses case, clarifying although the school can regulate a student's use of sexual innuendo in a speech given within the school. If a student delivered the same speech in a public forum outside school, it would have been protected. BL also spoke under circumstances which the school did not have a standing in loco parentis, because, And there's no reason to believe BL's parents had delegated to school officials their own control of BL's behavior at the Cocoa Hut. Moreover, the vulgarity of BL's posts encompassed a message with an expression of BL's irritation with and criticism of the school and cheerleading communities. Further, the school has presented no evidence of any general effort to prohibit students from using vulgarity outside the classroom. That would be hilarious. Does the school really want to go down that road? Does the school really want to try to put itself in a position of regulating all use of vulgarity by all of its students outside the classroom? That would be fun. Together, these facts convince us the school's interest in teaching good manners is not sufficient to overcome BL's expression and interest in free expression. Second, the school argues it was trying to prevent disruption, if not within the classroom, then within the bounds of school-sponsored extracurricular activity. But we can find no evidence in the record of this sort of substantial disruption of a school activity or threatened harm to the rights of others that might justify action. Rather, the record shows a discussion of the matter that took at most 5 to 10 minutes of an algebra class for just a couple of days, and some members of the cheerleading team were upset. Were they, though, or were they just trying to pretend to be upset for whatever gain? But when one of the BL coaches was asked directly if she had any reason to think the incident would disrupt class or school activities, other than the fact that kids kept asking about it, she simply responded no. So in the future, respond yes and see what happens at a different court of appeals, all right? As we said in Tinker, for the state, in the person of a school official, to justify prohibition of a particular expression, it must be able to show the action was caused by something more than a mere desire to avoid discomfort and unpleasantness. So yeah, more than that. The alleged disruption here does not meet this demanding standard. Third, the school presents some evidence that expresses, at least indirectly, a concern for team morale. One of the coaches testified the school decided to suspend BL not because of any specific negative impact upon a particular member of the school community, but based upon the fact that there was negativity put out there that could impact the students of the school. Newt says, do you think they could regulate speech made outside the school while wearing a uniform? Yes, probably yes, because if they're in uniform, well, it would be a stronger, let's put it this way. It would be a stronger case for it, because if they're wearing the uniform, it could be reasonably understood that the student is speaking with the school's imprimatur because they're wearing the uniform. So, probably. It would be a better case, right? That's a future lawsuit waiting to happen, right? One of the coaches testified that the school decided to suspend BL not because of any specific negative impact, but based on the fact there was negative impact out there. There's little else, however, to suggest any serious decline in team morale, to the point where it could have a substantial interference in or disruption of the school's effort to maintain team cohesion. As we've previously said, undifferentiated fear or apprehension is not enough to overcome the right of freedom of expression. It might be tempting to dismiss BL's word as unworthy of the robust First Amendment protections, but sometimes it's necessary to protect the superfluous in order to protect the necessary. Fair. We cannot lose sight of the fact that in what others might seem trifling and annoying instance of distasteful abuse of privilege, the fundamental societal values are truly implicated. So yeah, maybe this is trivial and not exactly the core of, whatever the First Amendment is reaching out for, is probably not exactly this. The First Amendment might cover this, but to suggest this is the zenith and paradigm of what the First Amendment was trying to conjure, probably not. Probably more on the trivial, peripheral end of it, all things considered. But by protecting the peripheral and trivial, we protect the core. Right? So the Supreme Court reminding us that free speech continues to be a thing, even in schools. So hey, yeah. JB says this really seems to state that in loco parentis is really narrow. At least when it comes to regulating speech, it is. Yeah, comparatively. Yeah. The idea of in loco parentis is definitely a lot narrower than it was before Tinker, that's for sure. Which I am assuming, without reading, that that's what Thomas is going to go into. I mean, we're going to see in about 5 seconds whether or not I'm right. But Thomas dissented. Why would he dissent? I'm going to guess that based on a local and based on a historical tradition, that Thomas is going to say, okay, schools have been in this position of a loco parentis. They're basically acting as parents. Therefore, the First Amendment basically doesn't apply because it wouldn't apply to the parents. And that's the historical understanding of this, blah, 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 so forth. So without even reading Thomas's dissent, I'm guessing it says some version of that. We'll see in about 5 seconds whether or not I'm right. But yeah. Although we do not agree, we agree with the judgment. Is so ordered. Fantastic. Just Alito concurs. Let's see. We'll just skim this. Let's see. It's important our opinion not be misunderstood. The court holds, and I agree. First Amendment. Now, again, why is this valuable? Why are concurring opinions valuable? Right? I mean, they may not be a majority decision. But if you think that the school and or parents will not be citing the concurring in their future lawsuits, and you don't think that the courts will be citing the concurring in their future judgments, you're out of your mind. All right? So this may not be the majority decision, but it will definitely inform the nature of lawsuits going forward. As you're looking for something to support your case, you'll take everything you can get, because why wouldn't you? Of course you will. So will you cite it concurring if it helps? Of course you will. It may not have won the day. For that matter, you would cite a dissent if it helps, right? Because, hey, maybe the dissent maybe there's a line in the dissent. You can't really quote this dissent for its controlling authority, but maybe there's a line in there somewhere that you can use as an idea. So why not? If it makes your case for you, good old times. The school holds that regulating silent speech is okay. The authority is more limited than exercise on speech. The courts should be skeptical lawsuits about what that means. And loco parentis rarely applies lawsuits. Protect unpopular ideas, lawsuits. I also agree that it's not prudent for us to attempt this time to set forth a broad principle. Okay. I agree. I start with this threshold question. Why does the First Amendment ever allow the free speech rights of public school students to be restricted to a greater extent than rights of juveniles who do not attend public school? Reasonable question. As the court recognized in Tinker, when the public school regulates student speech, it acts as the arm of the state. Suppose BL had been enrolled in a private school and did exactly what she did. The Commonwealth of Pennsylvania would have no legal basis to punish. So why has her status as a public student changed this? Our cases involving regulation of student speech have not directly addressed this question. All those cases involve either in-school speech or speech that was tantamount to in-school speech. And those cases, the court appeared to take for granted the special characteristics of the school environment justified special rules. Well, I think the answer to this question is not that difficult. And I'm not saying that okay. I think it's understandable. You don't necessarily have to agree with it or think it's right, but I think it's very understandable. And it's kind of like, okay, why should the state of Pennsylvania, or for any state for that matter, have the ability? So you have two juveniles, right? You have two juveniles. Same age, right? Same person, basically. One's in public, well, we'll do even three, right? One's in public school, one's in private school, one's not in school at all, right? And all three of them do the exact same thing. Say the exact same thing, do the exact same thing, whatever. And this court is asking, all right, why should the school have the ability to punish it in school when they can't punish it when it didn't occur in the school? And the answer to the question is somewhat unsatisfying because it occurred in the school, right? This goes back to the idea that, and for that matter, it could potentially happen to an adult too, right? So this is a little bit like asking, here are three different adults. These three different adults did the exact same thing. But one did it this place, one did it this place, one did it this place. One did it this time, one did it this time, one did it this time. One did it this mayor, one did it this mayor, and one did it this mayor, right? So it'd be a little bit like asking, hey, why can the state punish that person and not that punish, even though they did the exact same thing? And it'd be like, did they do it at the exact same time, in the exact same place, in the exact same manner? Is it because there's this detail over here that makes it quite understandable why? It's like, if I just do something in my own home, on my own time, I'm not bothering anybody, go nuts. The ultimate example might just be public disorder speech, right? I have a coffee machine here. Can I go to my coffee machine here in my house and, curse the world in loud, bulbous, even threatening speech? Sure, go nuts, right? But if I do it in my local Starbucks, which isn't a governmental place, but, or if I do it even in the middle of a city council meeting, or if I do it in the middle of, some other state thing, can the state punish me there? Sure. It's like, well, why can they punish you here and not there? Because it occurred here and not there. It's kind of the answer to this question. So in some sense, I feel like this is missing. It's like you're kind of answering your own question there. It's like, why can they punish me for going into the Starbucks and cursing out the world and doing all the same things when they can't punish me in my house for doing it? It's like, because you're causing a disruption of everyone else's time, the Starbucks is unable to function as a Starbucks because of you. And if this is a government-run Starbucks or government-run coffee house, same analysis, right? It's like you're disrupting literally everyone else. You're causing a problem. So why can the court punish this student because it's at school? Because it's at school. Now, you don't necessarily have to agree with that, right? You could think about the First Amendment analysis differently. But even as to adults, why did you do it? Why did you punish him here and not there? Because it occurred here and not there. Right? Time, place, manner restrictions among it's like, okay. I feel like you're missing something a little bit there. And Drazar points out the home is special. Fair enough. So, if it's a mystical coffee shop, self-serve coffee? Yeah, let's go with that. It's a coffee vending machine in the middle of nowhere. I can curse out the coffee vending machine because I'm not bothering anybody because no one's there. So, fair enough. Why the court takes this for granted is not hard to imagine. As a practical matter, it's impossible to see how a school could function if administrators and teachers could not regulate speech. Right. In a math class, the teacher can insist that we talk about math. In addition, when a teacher asks a question, the teacher must have authority to insist that they be responsive to the question, not some other question. And the teacher have the ability to teach. Practical necessity dictates that teachers and school administrators have related authority. Yeah. Because no school could effectively operate if teachers and administrators lack authority, the court may have felt no need to specify the source of this authority. But when a school regulates what speech, state, or right, they are not participating. Why should enrollment in public school result in diminution of free speech rights? The only plausible answer comes readily to mind is consent, either expressed or implied. The theory must be that by enrolling a child in a public school, parents consent on behalf of the child to relinquish some of these free speech rights. No, I don't know if that's true. I mean, because again, even on strict scrutiny grounds, I think you can get to where you need to be. You could get there for adults too, depending on the nature of the speech. Harassment can be illegal. So, fighting words can be illegal, technically speaking. So, I'm not sure consent really quite gets you there. And there's this in loco parentis idea. Blackstone explains the doctrine seems to treat primarily as implied in private employment, agreement between father and those who he contracted, blah, blah, blah. Education is compulsory and the state specifies minimum number of hours a day. Parents are not required to enroll their children in public school. They can select private school and they can educate their children at home. But 90% of students attend public schools. I'm not really sure this is super persuasive to me. It's not doing that much for me, personally. The degree to which enrollment in public school can be regarded as delegation of authority off-campus speech depends on the nature of the speech and circumstance which has occurred. Yeah, I don't necessarily even know that it's an issue of consent. It's just an issue. Again, it's like the school has to function as a school. We've decided as a society that children should go to school. In fact, must go to school. And the fundamental reason the majority is kind of going to the idea that there might be an opportunity to regulate speech, which I'm not sure necessarily the Third Circuit was saying they couldn't, just not under Tinker. So I'm not sure how much this is modifying the Third Circuit analysis really at the end of the day, but whatever. Supreme Court just wants to be clear about it, I think. And then they leave open a huge amount of holes to be filled by future lawsuits. It's like, I kind of know what the answer is, but, it's going to take a long time to get there. But the fundamental reason they can do it is because to the extent it's disrupting the school can't function as a school. The fundamental chief thing here that's sort of underpinning this entire analysis, Tinker or otherwise, is the school's got to be able to school. That's kind of at the underpinning of this. The school's got to be able to school. And if it's happening inside the school, Tinker, if not this, Mahanoy School District, or BL, probably got called Mahanoy, probably should be called BL, but whatever. Then the problem is, the reason we can regulate is because school's got a school. And that's the thing. So I'm not sure it deals with consent, not sure it deals with in loco parentis, as much as we got to make sure that we do not undermine the fundamental purpose for which the school is existing. So I'm not quite buying this legal analysis or thought analysis to my mind. And I'm not sure how much different it really is at the end of the day versus adults, because maybe it's the reason, maybe it's not even that it applies a little bit more. So maybe it's not even the legal analysis really changes. It's just that the way the facts break more often for the school than they would for an adult in a normal place, because the students are spending 8 hours a day, 5 days a week at the school, which is like not true of any other environment. So maybe it's not that the government gets more discretion to regulate the school than they would somewhere else. It's just that by nature of what schools are, when the facts are considered, the break comes out differently, or the breakdown comes out differently, right? So maybe it's not that if we were asking this question about an adult who is standing up in the middle of, say, I don't know, a city council meeting and behaving in a disruptive way, maybe it's not that we're really asking different questions. Maybe it's just that people don't live in the city council meeting, and they do kind of live in the school. So as a practical matter, when the facts are considered, the analysis comes out differently. So maybe the school doesn't really have any different authority than anyone else in the government does. It's just that because school is so consuming that when we say school's got a school, as a practical matter, that implies a lot more than, say, DMV's got a DMV, or even school board's got a school board, or even police department's got a police department, right? Because people don't live in those places, and the students basically live in the school. So maybe that's where it all comes down to. So I'm not really sure I'm buying this analysis for whatever value it has. Maybe it just really boils down to school's got a school. And as a practical matter, when the facts are considered, that implies more than it would anywhere else. So I'm not sure Alito's analysis is really doing anything for me. So let's see what Thomas is writing, see if it makes any sense. Let's see what Thomas's theory is. Okay, so the coach has 100. Majority outlines the scope of school authority. When students are on campus, the majority says school has in loco parentis. Off campus, somewhat less. At that level, generally, I agree, but the majority omits important detail. What authority does a student have when it operates in loco parentis? So when a school is within this domain, how much authority do they have? The majority simply points 3 vague considerations. They're definitely vague and leading to many lawsuits in the future, and reaches an outcome. A more searching review reveals school historically could discipline students in circumstances like that. I'm not sure how true that is, because the historical analysis really doesn't read on this because the facts are so different, but okay. Majority does not attempt to explain why I should not apply this historical rule. I dissent. I begin with assessment of the scope of free speech rights ordinarily incorporated against states, but looked what ordinary citizens would have understood. How much do you love Breyer? Matt says, so we all know how much you love Breyer on a scale of 1 to 10 about the Breyer. It's not great. It needs help. I'm not really. Okay, so yeah, cases and treaties from the era reveal public schools retain substantial authority. As I previously explained, that authority was nearly plenary while they're at school. Yeah, so this is basically the direction that Thomas is going. This is kind of the direction I thought. So how was freedom of speech understood? What did freedom of speech mean as applies to public school? And Thomas says, at the time, public schools had basically plenary authority, which, yeah, pretty much. So they could do pretty much anything. Yeah. So therefore, the First Amendment doesn't apply in this domain because they're acting in loco parentis and therefore essentially are not governmental actors at that point. They're just the parents. So the First Amendment doesn't apply to parents. It only applies to the government. And they're not the government, or at least they're not behaving like it right now. So that makes sense if you want to go down that way. Schools had less authority after student returned home. It was settled they still could discipline for off-campus speech that had a proximate tendency to harm the school. Perhaps the most familiar example applying this rule is a case where a student, after returning home from school, used disrespectful language. He called his teacher old in the presence of teacher and some of his fellow pupils. The Vermont Supreme Court held a teacher could discipline a student for speech because the speech had direct and immediate tendency to injure the school, to subvert the master's authority, and to beget disorder and insubordination. The court distinguished the speech at issue from speech in no way connected with or affecting the school, and speech that merely has remote and indirect tendency to injure. In inquiring this, they use proximate causation. That makes sense as an underlying legal theory. I mean, it's logical if you want to go this way. Too much for me. So maybe I'm just not as conservative as Justice Thomas is. It's logical. It makes sense. It's even perhaps more keeping with the, originalism in terms of the school. But, it's just too much. So, it's where maybe maybe this originalist has a slightly fainter heart. It's like, I'm not going to go that far. Not for the least reasons, I consider to be freedom of speech to be a fairly paramount value. The rule is widespread. So widespread, it served not only as a basis, but also to regulate truancy. Although modern doctrine draws a clear line between speech and conduct in the 19th century, not so much. I believe that. Citing some case, school justified truancy because of its proximate tendency, also its conduct. Schools could regulate it because its subversive effect. Some courts made the statements that, if read in isolation, could suggest schools have no authority at all to regulate speech. But these courts made clear the rule against regulating off-campus speech only applied when the speech was non-wise connected with the management or successful operation of the school. Yeah, so basically we're just going full bore. We're going full bore in loco parentis. That's basically the underlying theory. The First Amendment at the time, freedom of speech was not understood to apply to primary schools. Now, you can't say it wasn't. You can't say that it didn't. There is one slight wrinkle here. There is one slight wrinkle, and Justice Thomas isn't quite acknowledging it yet. And actually, you could turn the legal analysis on this, and Justice Thomas is either ignoring it or not addressing it or something, because this is when they're talking about these decisions, right? They're talking about primary education, right, or low secondary education, right? They're talking about like K through 5, K through 6 decisions, right? They're talking about children that young, right? They're not talking about high schoolers in that era. Do you know why they're not talking about high schoolers? High school hadn't been invented yet. High school hadn't been invented yet. So that would be why. They're not talking about high schoolers. So, yeah, if you're going to go with the originalism idea of at the time, they stood in loco parentis, and the authority of the school was as parents, as basically absolute non-governmental actors, basically all that. You could still very logically say, well, those decisions only applied to non-high school students because high school didn't exist yet. So we're not quite sure what the founders would have thought about high school because it hadn't been invented yet. So you could logically distinguish between high school and non-high school, which might be very logical indeed, depending on your point of view. Maybe from first principles, the school should have more of an absolute authority for K through 5 and less so for high school, and even less so for colleges, right? So that would be logical and in keeping with the precedent. DSS says, you may not know him, but Eric Brandt loved your breakdown. He also can't be here to watch them because he got 12 years for his hope and dreams. Sorry to hear about the 12 years. Hope it works out for you, ma'am. In the end. So, yeah. So Thomas is somewhat ignoring the fact that this is high school, and high school hadn't been invented in 1776. If there's a good constitutional reason to depart from the rule, the majority in part is to thus apply it. Our modern doctrine is not to the contrary. Schools can publish vulgar speech, at least when it occurs on campus. Fraser, sure. The discipline here may seem disproportionate, but does not matter for our purposes, unless it's cruel and unusual, which is definitely not. The majority declines considering this history. Consider the court's long-time failure to grapple with the historical doctrine of in loco parentis. That's fair. 14th Amendment was ratified against the background that legal principle that publicly funded schools operate not as state actors, but as substitutes for parents. This freed schools from the doctrines of the 14th Amendment, which has all kinds of implications, incidentally, now that I think about it. Because you know what that would mean, incidentally, and I assume Justice Thomas would have absolutely no problem with this logical conclusion, right? So if schools are acting in loco parentis, that is, they are the same as the parents, right? So the 14th Amendment doesn't apply because for the purposes of our exercise, they're not governmental actors. They're the parents, remember? Which means the First Amendment doesn't apply. But it also means all the First Amendment doesn't apply. None of it, right? So if you go down this road, there would be nothing stopping a school from, say, for example, compelling students to stand and recite the Pledge of Allegiance, or to pray to a Christian God, or read the Bible, or any of that stuff. Because a parent could do it, so they're just the parents, remember? So if you go down this road, you can compel students to pray, you can compel students to stand and recite the Pledge of Allegiance, you can make them read the Bible and pray to a Christian God. And if they don't, you can punish them. So, I mean, I don't know if, I assume Justice Thomas would be totally okay with that. But that would be the logical implication of all that. So, there's that. Plausible arguments can be read in favor of departing from historical doctrine. When the 14th Amendment was ratified, 3 jurisdictions had compulsory education laws. That would also, so there's an idea. Even if schools had this absolute authority of in loco parentis, something changes by compelling it. Because now it's compelled. That's logical. That's a reason to depart. And also, there's a due process element in there somewhere. So that's fair. One might argue the delegation logic of in loco parentis only applies when the delegation is voluntary. Yeah. The court, however, did not make this distinction. Instead, it simply abandoned it without mentioning it. Yeah, so there is a basis. Like, because it's compelled, if you voluntarily turn your kids over to a private school, the private school can do anything. Pretty much. I mean, short of abuse. So, But, so the public school is no different. But once it's compelled, changes the logic? Yeah, that makes sense. The majority does not do better with the local parentis. So Justice Thomas is salty that the majority is kind of ignoring the in loco parentis thing, which is such a Justice Thomas thing to do, because it's such Justice Thomas, for better or worse, is such an ideological purist sometimes. And so it's like, oh, you're not dealing with this ideologically pure thing. Now, I do appreciate ideological purism, but Justice Thomas pushes it past my comfort level. It's like, I don't know. I don't need to deal with that right now, Justice Thomas. Can we not deal with the in loco parentis thing? I just don't need to deal with this. It's like, no, we must have. I'm like, I just can't be bothered. The court's failure to explain itself in Tinker needlessly made this court more difficult. Tinker, which involves school authority on a straight fact parent, this involves something more difficult. Blah, blah, blah. Okay, the majority uncritically adopts the assumption the speech was in fact off campus. The location of speech is much trickier than the majority acknowledges. Because speech travels, schools may sometimes be able to treat the speech as on campus, even though it occurs off. I'm not sure that the originalist history helps you there. School transparently takes a common law approach to today's decision. It affects just one rule, blah, 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 whatever, yeah. So, yeah, that makes all sense. So, yeah. DSS says I don't have to pray to any one God, period. It's in the Constitution. DSS, what part of my analysis did you not understand, man? I don't know if you're contradicting me or not understanding me, so sometimes it's a little bit frustrating. But yeah, my entire analysis is like, no, it doesn't apply because we're in this different status for this reason. And okay, never mind. Aren't schools and parents in plenty of states allowed to beat kids? Beat, no. Corporal punish, yes. And there's definitely a distinction between those two things. Yeah. So the Supreme Court's decision is best read as saying the school's authority to regulate off-campus speech is deeply constrained, but not. So yeah. So that's good times. So yeah, all that good stuff. Pretty interesting stuff. Pretty interesting decision. So F cheer is still allowed. Now, yeah, again, the analysis changes if it's on campus or during a school event or wearing a school uniform or engages in conduct that's not speech, which this doesn't deal with at all. So this case doesn't deal with the possibility of a student punching another student off campus. Can a school regulate that? In addition to whatever the police might be able to do. The case doesn't deal with that at all. So, DSS says, I respect the apprehension on the local parentis discussion because it's very, very case-dependent argument. Honestly, I hope you come around to it needs explaining. Fair. Totally fair. Totally fair that the in loco parentis doctrine as such needs more explaining. But yeah, that's totally fair. Yeah. But this is, yeah, so Justice Thomas's dissent doesn't really do anything for me. Alito's concurrence doesn't really do anything for me. The majority's decision seems better, even though it's written by Breyer. I'll take what I can get. And we have this wishy-washy three-part analysis where the Supreme Court giveth and it taketh away and leaves open for many, many rooms of litigation to go. So maybe I should just change specialties right now. I can change my job and do this, because this is going to be 20 years worth of legal practice that's happening. So all that good stuff. Okay, that's enough for now. If you're enjoying this legal education, please remember to hit the notification bell. If you're not already subscribed, you can hit the subscribe. And did you know for 99 cents you can support the channel? It's true. You can hit the join link that's being provided by Streamlabs, or the little join button. Either one is fine, and help to provide the channel support. We're trying to cross 19,000. We're getting pretty close. Or what am I at? No. How many subscribers do I have? Hold on. I've forgotten. Hold on. Is it 24.9? 25.9? I'd forget. Hold on. $25.8. Okay, so we're trying to get to 26,000. We're trying to get to 26,000 right now. So if you have, if you've not already hit the subscribe button, please hit the subscribe so we can get to 26,000. And at this pace, maybe by the end of the year, 30,000 or maybe a little bit more. That'd be cool. And things are looking good. So all that good stuff. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers and goodbye.